final one of 3 in our series. Chris Cook started us off looking at employment contracts and restrictive covenants in those, and then Vincent Billings and Jeremy Scott joined us at the same chambers as Helen, looked at restrictive covenants in commercial agreements like shareholder agreements, business sale agreements and the like. And today Helen and I are going to be looking at what's involved if you need to stop former employees or shareholders from competing with your business when they've signed up to something that says they won't do that. Covenants could be in any one of the types of the agreements that have been covered in the first 2 parts of our series. The procedure is essentially the same for all of them, but the law and what a judge will need to be satisfied on to actually enforce a covenant differs between them. And you'll be able to find out more about that if you watch back for the first 2 episodes. The procedure is also broadly similar to what's involved in enforcing covenants that protect confidential information, and that type of claim is often bolted on to claims to enforce restrictive covenants, because you'll find the 2 provisions side by side very often. So handing over to Helen, she's going to cover the legal options first, and then I'm going to look at things from a practical point of view. Then we're going to look at commercial considerations before you launch into a claim as well as during one, and then wrap up with some signs and on tips on signs where someone might be looking to compete, how to deal with policing, court orders and settlements, and finally putting recovery plans in place to deal with the consequences of someone breaching. So with that, over to Helen, and for those of you that don't know her, she's a very experienced commercial barrister at Outer Temple Chambers who has plenty of experience of actually being on her feet in front of High Court judges, arguing that your business or a business should be able to enforce this kind of covenant. So it's first-hand experience from the coalface. Over to you, Helen.
Thank you, Simon, for that introduction. Good morning, everybody. I had the joy of watching the recorded version of Vincent and Jeremy's talk last week, and saw a lot of passion there for restrictive covenants. I can't promise to sound quite as passionate, but it's certainly a topic which is very close to my heart. In terms of the talk then, there's Simon. I'm going to set out what you're enforcing and then what your enforcement options are, and then Simon's going to deal with some of the commercial and practical considerations. So just to recap then on what you might be enforcing through the options I'm going to talk you through. Well, you have to check first, is it going to be a restrictive covenant, or is it merely an ordinary term of the contract? A restrictive covenant might be one of 4 types. It might be a non-soliciting restrictive covenant. That's where you're trying to prevent the former shareholder or the former seller of the business from approaching the business's former clients or current clients. So that is aimed at an approach. Slightly non-dealing. This again is aimed at preserving your business's client base, and it covers non-approach situations as well. So where the client might go to the vendor or might go to the other shareholder. It's broader. That means it's slightly harder to enforce. That's not to say that if properly drafted, you can't successfully enforce those types of clauses anyway. Non-poaching, this is where the clause is aimed at preventing the shareholder or the vendor from taking away your business's workforce. And then finally, a general non-compete. So that's where you're trying to prevent somebody from leaving your business and joining a rival business. These are traditionally slightly harder to enforce, but again, if properly drafted and with the proper legal support, not to say that you won't be successful in a lot of cases. So first things first, who are the correct parties? Well, this will depend on your agreement. So if it's a shareholder agreement, it'll be shareholders. You might need to join the company. If it's a share purchase agreement, it's going to be the purchaser. And if it's an employment context, then you're going to have to identify the correct employer. And in all cases, make sure you have the right authority from the right people or entities or board to seek the legal advice and take the action. So those are the considerations that you want to be looking at. Enforcement options. There are two enforcement options that you're going to want to consider initially. First of all, is the pre-action out-of-court settlement options. So you might enter into settlement agreements, you might have undertakings. Then there are the court options, interim injunctions, final injunctions, declarations, financial relief. So that might be claims for damages if your business has suffered loss as a result of the breach of restrictive covenant. And then they in turn, that court route might end up not going to final trial, and you might settle that partway through with court-backed undertakings. Now, deep diving into that a little further. So out-of-court settlements, just because you might have heard the phrase unenforceable, illegal, void, doesn't mean that the parties cannot voluntarily enforce these undertakings. You don't need the approval of the court to do so. Pre-action undertakings or settlement agreements will take effect as a binding contract. So again, it's best that you take advice on the wording of the settlement agreement, because if you end up having to enforce that settlement agreement, you're going to be subject to the same scrutiny as your original contract and restrictive covenants would have been subject to. This is care of Simon. This was a very general mock-up of a settlement agreement or undertakings that I asked Simon to do, and then I reduced it considerably, but it should give you the general flavour. So you see there, you have the recital, then you have a provision about future conduct, and that's where you're going to put in your detailed undertakings, which are going to mirror, to a large part, what your restrictive covenants said. And disclosure, it might be that in any particular case, you're going to want disclosure of information. It might be a case, for example, where your business has suffered loss, but without obtaining details from the defendant, you're just not sure how to quantify that loss. So there might be disclosure provision in your settlement agreement. You might want an account of profits if they have, for example, exploited your confidential information, if they've taken clients of the business away. It might be that you agree with them that they will reimburse you and account for that loss. And then other provisions that you're likely to want to think about: the return of company property, if that's an element of your case, if they've taken client lists or other information, company pro forma documents, for example, and then legal costs and indemnity. So who is going to pay for the costs of having got to the point of this settlement agreement? Now, if the out-of-court route doesn't work, and I should say here that in reality, in practice, most of the time, you're going to solve everything pre-action without going down the court route, particularly if your restrictive covenants have been drafted well in the first place. There is going to be less for the defendant to argue about, and they're not going to want to take the risk of going to court and losing, with all the costs and time and reputational damage that might lead to. The other thing is you might not want to go down the court route, and you might be willing to compromise something less than full enforcement of your restrictive covenants. Certainly, I think Simon will agree that our experience is that very often negotiation and settlement out of court is the best way to go about it. But if not, then you're into interim injunction, final injunction, damages, declaration territory. And by far the most useful court option, court remedy in these type of cases is the interim injunction. An interim injunction is obtained without needing to go through all the case management stages, without having to issue, without going through all the intermediate steps, without going to trial. And it's obtained at the beginning before that happens. And it's designed to hold the ring before the parties can issue and then go through all the options. It's almost certain that the claimant would have to give an undertaking to issue within a certain period. So you're not getting out of the full claim at this stage, although of course you might settle with the defendant and avoid going down that route. Rather, you're getting injunctive relief at the start to prevent harm occurring to your business while the dispute is settled by the courts, or perhaps settlement later down the line. Any claimant requiring an interim injunction is almost certainly going to have to give cross undertakings. So there are two types of undertakings that you'll hear me talk about and Simon talk about. We've discussed the undertakings given by the defendant. They're essentially promises not to contact your clients or promises not to steal your employees for a certain period of time. There are other types of undertakings, which we typically call cross undertakings, which are given by the claimant. And these arise in interim injunction cases. And the court will almost certainly expect the claimant to give a cross undertaking that they will issue the claim within a certain period, and that they will pay any damages to the defendant that's incurred as a result of the interim injunction if that interim injunction is proven to be wrong. So if you fast forward to trial, if your restrictive covenants are not upheld, they're considered to be unenforceable, and your final injunction is not obtained, or your final financial relief is not granted, then the court will consider that you shouldn't have been granted the interim injunction. And the cross undertaking will then take effect at that point, and you'll be responsible for paying the defendant any loss incurred as a result of being subject to that injunction. Interim injunction is granted on American cyanamide principles. That's the name of the initial case which set down the rules. And effectively, the court will ask, is there a serious issue to be tried? And if so, what is the balance of convenience? Now, a serious issue to be tried is a relatively low hurdle. You simply have to show an evidential basis for the argument that there is uncertainty and the matter needs to be resolved at trial. But I emphasise you need the evidential basis. You can't just rock up to court and allege something without having collated some evidence that there has been, that the restrictive covenant is enforceable and there's been breach and loss. Balance of convenience. In reality, in practice, this means, and I'm just trying to click on the slide. For some reason, it stopped me moving the slides. I don't know whether Simon, can you move the slide at your end?
I will try. Hold on.
Thank you. So balance of convenience in any event means where there is harm potentially to both parties, the court is going to weigh the respective harm. So the court will weigh the irreversible harm to the claimant if the injunction is not granted versus the irreversible harm to the defendant if the injunction is granted.
Is that about where you need to be?
Yeah, that's perfect. Thank you, Simon. So the court will consider, will damages be an adequate remedy for the claimant? If not, then the court will go on to the next stage and consider whether the cross undertaking to compensate the defendant for any loss incurred while the interim injunction is in place will be adequate for the defendant. And of course, the parties' means are relevant here. If the answer to both those questions is no, then the court will stand back and look at the general balance of convenience. In some cases where it is likely that the interim injunction will be depositive of the case, so this is in cases where the restrictive covenant you want to enforce is only for a short term, and the route from interim injunction to final trial is longer than that period, then it's highly unlikely in practice that the parties are going to battle all the way to the end. So in those cases where the interim injunction effectively front loads the decision, the court will consider the merits in some greater detail. So again, it's important to have the evidence in your favour at that early stage. Thank you, Simon. Costs. The costs are not always straightforward. If the interim injunction is reserved, if the interim injunction is granted, you will not necessarily get your costs at that stage. It's likely to be reserved to the determination of final hearing or wrapped up in any settlement agreement that you agree. Next stage is court-backed undertakings. I mentioned before undertakings in the context of pre-action out-of-court settlements. The difference with undertakings when you've made the application for an interim injunction is that the undertaking given by the defendant will be given to the court, and there will be a penal notice, which means a breach of that undertaking will be a breach of court order and a contempt of court. So you have an added sanction there against the defendant, and not only will you be able to enforce the order, but you'll also be able to enforce as a contempt of court if that's the route you wanted to go down. So that's interim injunctions. The next slide, I think, is going to talk about springboard injunctions. Simon, if you don't mind bringing that up. Well, I'll carry on. I'll just talk you through springboard. Springboard injunctions differ from an interim injunction in that they're used to not to enforce a restrictive covenant, but rather to prevent the defendant getting an advantage from having breached a restrictive covenant or a confidentiality clause, which, as Simon mentioned, it is often closely associated with restrictive covenants. So a classic example of a springboard injunction is where the vendor has taken your client list and has started to and it's passed those client lists over to a rival or a competitor, you can go for a springboard injunction, not just against the vendor, but against the new business to prevent them using that confidential information for a certain period and obtaining an advantage. The route following interim injunction is then your usual claim route. So you will need to issue, there'll be particulars of claim, defence, reply, case management stages, and you'll be seeking a final injunction. Or if the time period is shorter than the time it's going to take to get to trial, so that you no longer need an ongoing injunction, it might be that you still want damages because there's been a financial quantifiable loss to your company. The damages or the declarations or other remedies that you're going to want at the end will also need to be carefully evidenced. Thank you, Simon. The final injunction and the interim injunction as well, it's worth mentioning, they are discretionary relief granted by the court. So you will need to prove not just that there's been a breach of, well, that the restrictive covenant is enforceable, and that there has been a breach, but you'll have to show that it is equitable to then obtain the injunction. My practical experience of this is that that is rarely the point at which the claim fails, because once there has been a valid covenant which has been breached, in the type of situations that we're looking at, the court is going to normally grant the injunction. But there might be occasions, in theory, where you fail at that final hurdle. That deals with the out of court and in court options. And now I think I'm passing over to Simon to discuss some of the more practical issues surrounding those options and how you go about deciding what's best for you.
Helen, can you hear me? I'm sorry, my connection has just dropped completely. My apologies to everybody watching.
Yes, we can hear you fine, thank you, Simon.
Okay, you ready for me to go ahead?
Thank you.
I'm going to stop.
Sorry, everybody, we seem to be having technical problems this morning.
Helen, can you hear me? Is that working now?
I can hear you, Simon. I can't yet see you.
No, I'm going to keep the camera off. My apologies. It's appalling.
Can you share your screen at all?
Yeah, let me just sort that out.
We're just getting to the interesting bit, Simon, where you were going to tell them about the practical considerations.
Right, hopefully that's working now.
Yes.
Excellent. My apologies, everybody. The next call is to Virgin Media. So much for their 100 megabyte fiber. Anyway, okay. What's involved from a commercial and practical perspective? The first thing to look at is who's going to be in the team that you, apologies, hang on. who's going to be in the team that's going to be involved in pursuing the guilty party. Very much a team effort, and if you can't get the pre-action undertakings that Helen was talking about to get you where you need to be, then there's a lot of work to be done in a short period of time. Delaying an application for an injunction can also prejudice that application, so you really do need to get your skates on and get moving as soon as you realise that there may be potential breaches, because a judge will take delay into account, and that can be particularly harmful at the tail end of a restrictive covenant if someone thinks they might try to compete for the last couple of months or so. The client team needs to be able to devote time to the case and prioritise it above day-to-day work, generally speaking, and be able to give input into what's often fast-moving correspondence and negotiations. And if you are going to have to go beyond those and look at court, there's also going to be witness statements to be prepared, which is a fairly onerous job. So members need to be available before and after any court application. If you are going for the without notice application, which I'll come to in a moment, there will be what's called a return date that will come on maybe a week or so after the first hearing. So it's not just a question of being available for one hearing. In terms of the client team, you also need to look at limiting that to those that really need to know about what's going on and be involved to prevent any issues with privilege being lost. And also, if the matter involves secrecy and that you don't want to tip the defendant off as to what you might be doing for any particular reason, which I'll come on to, the fewer people are involved, the better, because it reduces the risk of tipping the defendants off. Legal team is going to be solicitors who will provide initial advice, find suitable counsel like Helen if we need to go to court. We'll also prepare initial letters which will be threatening enforcement in cases where the secrecy isn't involved, and typically that letter of claim will request undertakings as well. And those are the pre-action undertakings Helen was mentioning, which will, if given, will form a binding agreement that will be enforceable if those are breached. You may well look at bringing counsel in at this stage if you're in a borderline case, because you'll want to make sure that the undertakings that you are trying to extract from the defendant are realistic in terms of what you could get if you went to court, because you could find yourself with problems in terms of recovering costs later on if a defendant can say, well, I was perfectly justified in not giving the undertakings that I was being asked for because they were completely unreasonable, and the court, I was never at risk of having to go under that kind of enforcement from a court order. Then counsel will deal with the advocacy at any hearings that are necessary, and in the background, solicitors will be getting on with preparing witness statements and evidence for those hearings. Solicitors will also deal with issuing and serving any claim form that may be necessary. The important thing to remember with injunctions is that they aren't a claim in their own right very often. As Helen said, the interim injunction is something that's designed to hold the ring, and you need an underlying claim beneath that to be able to, that has to be issued, and that easy to overlook, but you need to be able to be getting on with that as well. And because of the volume of work, it makes time to get the team aligned and together early so that everybody's working toward the same common end. Okay, moving on to evidence, which Helen touched on. You're going to need definitely evidence of the breach. That will need to be clear evidence, and it'll need to come from people who can speak to it firsthand. Court will attach far more weight to this than it will to those who are more removed and are effectively passing on information that they've got from somebody else. the evidence needs to be clear and cogent and complete. There's no oral evidence at the interim stage, so it's vital that witness statements are comprehensive and easy for a judge to follow and for the advocate for counsel to take a judge through. The evidence also needs to address what the defendant has done to breach, as well as what they could do if they weren't restrained. A judge is unlikely to be persuaded simply by fear and concern as well. It's always better if you can actually point to some actual breaches or threats of breaches. Evidence on loss, again, needs to be very clear. If there is any at the interim stage, a judge won't expect chapter and verse at the early stage, but proper evidence is going to be required, potentially from accounting experts, if you get to a point in a case where you're pursuing damages and you need to prove loss of profits if you get as far as trial. Urgency is one of the big issues to look at the start of any case. The starting point from a legal perspective is that no order should be made against a party unless that party has had the opportunity to be heard. The court rules allow without notice applications. That is an application where the claimant goes to court and asks for an injunction without telling the defendant, and the first they know about it is when a process server turns up on their door and slaps them with the injunction that's been granted. To be able to make a without notice application, you have to show good reasons for departing from that basic principle. The reasons will have to be dealt with in the main witness statement that supports the application. There are two key criteria. One is giving notice is likely to cause the applicant itself injustice through delay or steps the respondents could take to make to slow things down, basically, before an order can be made. And the other reason is going to be where giving notice of the application would destroy the purpose for which the application is being made. So if, for example, a defendant could run off and destroy evidence, for example, if part of your claim is going to be for something like the return of a database, if they were to find out what you were going to do, they destroyed the evidence of that would obviously defeat the purpose of the application or part of it that you were making. Reasons are always fact sensitive, but the court is going to need to have good, solid evidence to justify any without notice application. If it's not satisfied that the matter is genuinely urgent and deserving of that kind of hearing, it'll either dismiss the application you're making or adjourn it until proper notice has been given. It's also worth noting that if you go without notice, there is more to do after the hearing itself, whether you win or lose. For example, you have to serve the defendants with a full note of the hearing. So moving on to disclosure. If you're applying without notice, the claimant is under a duty to make a fair presentation to the judge of the material facts and the law that's relevant to the application. One way to look at that in practical terms is that you should be saying to the judge anything you think that is reasonable that the defendant might do, so that the judge has all the material facts in front of them. A breach of that duty may well be a ground for discharging an interim order that's obtained without notice. That can have quite significant potential adverse costs implications and also implications for the cross undertaking in damages that Helen was talking about earlier, which I'll come back to in a moment. And this duty of full and frank disclosure is a good reason to get the client and legal teams right and working together from the outset to make sure that all aspects of the case are considered properly to avoid or minimize the risk of breaching the duty, because it's very easy to overlook potential adverse points when you're trying to beef your own case up as much as possible in a very short period of time. Confidentiality, apologies, and anonymity are also important considerations to take into account. All proceedings are public, are in public. You can seek anonymity orders, an example of the super injunctions of days past, but you need proper grounds for this. Publicity can sometimes be a disincentive for claimants, but it also critically can be a disincentive for a defendant who's threatened with an application for an injunction against them. If you put yourself in their shoes, they're probably trying to start up a new business or work for a competitor, and they may well not want the adverse publicity that can go with them being hauled into court, particularly if they're effectively banged to rights and they are breaching. They are likely to want to avoid exposure. So it's something you can leverage and factor into your tactics early on. Cross undertaking, again, coming back to this, it's the price for getting a without notice order. On a without notice application, claimant is very likely to be required to give the court an undertaking to make good any damage the defendant suffers as a result of the order. And the claimant's evidence in support is going to need to go into a reasonable amount of detail to prove to the court that it's going to be good for the money if the order that's being sought is made. That can be a disincentive for some companies because they don't necessarily want to, or may not be in a position to give that evidence. It's also worth bearing in mind that a defendant can apply to the court at a later stage to ask the claimant to fortify any undertaking, which can lead to money actually having to be paid into court or security given. So moving on to commercial considerations, again, early points to think about. There's 4 common drivers that are set up there. The first is key, and it's not uncommon at all that the decision to go after a leaver will be taken after others have left, and maybe no action's been taken, and the company decides enough is enough, and an action is launched to discourage others. All of these, though, need to be balanced against the risks of losing, which is why early legal advice is important. If you think about the starting point about any restrictive covenant is that it's unenforceable unless it's reasonable in terms of time and scope. These kind of actions aren't without their risks. And you also need to think about whether or not you're going to include a damages claim, because that's going to add cost, complexity, give the defendant more to argue about. And in some cases, people will just simply won't pursue damages just because they want to stop competition in the bud before it goes further and bring the defendant to heel. Cases can and do go on towards trial over damages alone if interim arrangements to hold the ring, as Helen said, are put in place. But in reality, they're only going to go any distance in relation to losses if the costs of that exercise justify it, and also where you've got a defendant who's likely to be good for the money in terms of losses that may have been suffered, and also paying the costs of that exercise if you win. So it's some careful thoughts needed around that. And it's important to be clear about the objectives from the off and have a strategy that's going to get you there. And also you need to be ready to adapt that strategy. I can remember a case a colleague was involved in where we got undertakings from this chap not to compete and to be a good lad and abide by what was in the agreement we were enforcing. And as part of that, we had a feeling that he probably taken company property. So there was a provision in the undertakings to return all company property. And when that arrived at our office in a box and was opened up, we found a whole load of notebooks that revealed that his poaching of clients was far wider than we expected. which meant we adjusted the strategy and went after that, and actually then started looking at recovering money from him as well as that, because it suddenly became viable to do so. Timescales, always as soon as possible with cases like this, that they're always urgent. In terms of the steps we've been talking about, if an application for that notice, you want to get it in front of a judge as soon as possible. If you're sending a letter first, then you probably set something short, like a 2-day deadline requiring undertakings before then. What may happen is if the defendant runs off to solicitors who say this is 2 days is far too short, then you may negotiate some sort of interim agreement with them that behaviour may stop for a short period until they've had a time to set out their case properly. If you are going to launch an application in court for an interim injunction, you're probably looking, if it's on notice, with getting in front of a judge within 2 to 4 weeks. If you have to serve the claim form and particulars of claim we've been talking about, that's likely to have to be done, say, 2 to 6 weeks after any interim relief is granted. And cases like this could take 6 to 24 months to get to trial. It just depends what's involved and the amount of court time that will be taken up. It's worth noting at the moment, and depending on which court you're in, court diaries are pretty congested, and the amount of time that a case could drag on over may well be a driver towards looking at a sensible, workable commercial result that gets you the protection that you need, rather than, say, going on to argue a marginal damages claim over time. Reputational risks are also important to think about at the outset. How are you going to achieve your aims once you've worked out what those are? Confidential out-of-court settlement agreements with undertakings, etc., very, very common, as we've said. Public hearings have a definite plus if you are trying to show that you are the kind of organisation that will enforce your covenants to disincentivize other people from leaving. However, in marginal cases, you need to think about the risks of potentially losing, washing your dirty linen in public. How would that go down with your own staff, customers, etc.? It's not uncommon to see businesses destabilized by a spat between founders when one has left, and they may feel that their own futures are impacted by this, or they might start thinking about whether their own covenants are worth challenging. And a public loss obviously can also have a huge impact if the covenant you try to enforce is in a lot of contracts, because effectively you're setting a precedent. That said, a public win can have a real deterrent effect against that. You also need to look carefully at the defendant's financial position. How far is it worth going? There's nothing worse than getting a complete legal win against a defendant that then can't pay. A pretty piece of paper with a red seal from the court on it saying that the defendant must do this, that, and the other isn't really worth much if it's cost you a lot of money and you're not getting anything back in terms of financial recompense, if that was what you were after. However, you can also look at situations sometimes where a loss can still be a win if you launch an action and the aim is to stop the defendant competing for a period of time and divert them from their new business while you build up your own relationships with let's say, the defendant's key clients that they've got. Even if the defendant in a marginal case can force you to back down or force a settlement on less favourable terms, that might legally, the lawyers may see that as a bit of a loss, but if that was enough to burn the competitor in terms of time and costs and frustration and stop them starting off their new business in the way that they wanted to, or effectively getting you a period of garden leave if they're joining a competitor, or stop their clients going with them if they know the new business is going to be beset with legal issues, that may still be a win in practical terms. Costs and cost recovery are obviously a big question. The simple starting point is if you win, you won't get everything back because of the way the costs rules work. You also need to say, as I've said, is the defendant able to pay costs? The court fees for these can be quite expensive as well. The court fee for an injunction alone is £528, but that can spiral up rapidly if you're attacking on money claims for damages. 5% of anything you're claiming up to 200,000 and a flat £10,000 after that. You also need to factor costs into your cash flow. There'll be monthly bills from lawyers and solicitors and barristers, etc., as well as court fees. And if you get an interim application, if you get an interim order in your favour, the general rule is that costs won't be awarded at that stage. They'll be held over until the end of the case. Now, if the case settles before trial, that's going to mean that those costs are left up in the air and going to be the subject of negotiation. And generally speaking, the stronger your case, the more chance you have of forcing a deal on costs. But it's pretty common to see defendants fighting over that. There is some very, very recent case law from the last week or so where a court did award a claimant at the interim application stage costs, but that was simply because the defendant's conduct had been so shoddy. The judge was of the view that it should be penalised in costs at that point. That will be a big slap for the defendant, because obviously that means they won't have money to fight on necessarily, as they may have intended to in their strategy. And it also sort of points towards the need for claimants to try to take sort of the legal and the moral high ground if they can, and force the defendant into a corner to see if you can extract any leverage from that. Coming toward the end now, talking about where we were in terms of, is anyone planning anything? Traditional way that people would find out that something might be happening to justify you're thinking about taking action or be ready to take action if somebody does leave. Keeping your ear to the ground. It's difficult at the moment. Everyone's working from home. There's limited staff in offices, but it's a good looking at the current virtual office space, it's a good reason to make the catch-up calls to staff you've maybe been meaning to do, keeping in regular touch with them. You never know what you may find. Another telltale sign was often people in the office, potential leavers in the office at all times, odd hours for no good reason, looking at material that wasn't really related to their roles, emails to their personal addresses, making contact with ex-staff, perhaps, forming new and unexpected friendships with staff that they may be looking to entice away. With working from home, it's worth looking at your policies that you've got for monitoring staff activity on your network, on your VPN, whatever. What are they looking at, when, how are they doing it? Is stuff being printed, perhaps? Are little groups forming that you wouldn't have expected to for some reason? Our employment team can help with reviewing policies or getting policies for workplace monitoring in place. It's a sensible thing to look at, as is tighter restrictions on passwords and access to documents in relation to who can see what and do what with it. But bear in mind, it's very easy to photograph laptop screens and then print at home from phones. Also worth thinking about how you can keep eyes and ears on a sparsely populated offices. Now, I don't know if, Helen, you've got any experiences from your cases about things like this, but you can add.
Hi, Simon. Well, I think the new virtual working from home world does make it a bit more difficult for employers, because the normal telltales that you're mentioning rather assume that people are around to visibly watch, save for obviously all those documentary online reviews and monitoring that can go on. I think nowadays one can't underestimate the importance of picking up the phone, not just to staff, but to existing clients as well, and just finding out who they've been talking to in your organisation and seeing if there's any red flags that have gone off there, and whether that have those individuals within your workforce, have they been diarising those meetings, and have they mentioned them to their line managers or in group meetings, where normally if it was a normal conversation, you'd expect them to. So I think, unfortunately, there's going to be a lot more effort that needs to go into checking out and finding out whether any of this sort of activity is going on. Whereas previously, you quite easily, in many cases, be able to spot when somebody was away from their desk and notice that they weren't diarising certain meetings, perhaps. You have to come at it from a different perspective this time. And I would suggest that speaking to your existing clients is one of the best ways of doing that at the moment.
Yeah, that's a good point. Segues neatly onto my final slide about policing and recovery plans. They're the final part of the jigsaw. Once you've got you've enforced, however, whatever option you've gone down, and you've been able to stop the the competitive behaviour that you wanted to, making contact with potentially vulnerable clients who might be tempted to go with the lever, and their contacts to protect relationships is incredibly valuable. You really need to do it, but it can also be really useful for evidence gathering and uncovering further breaches of undertakings or orders. It's not that common, but it's not unheard of for people to breach undertakings and orders that they've given, that they've had made against them going down the line. And as part of the work you're doing to enforce, I think it's also important always to look at a strategy to protect relationships in the build-up toward the end of a restrictive covenant period or an injunction or an undertaking, to guard against the potential for a free-for-all when they lapse. So that, I think, brings us pretty much to time. Apologies again for the technical issues earlier. I don't know if anybody's got any questions that have been typed in. Victoria, you can hear me?
I can. Hi, Simon. There's no questions at the moment, but we discussed on the chat that we're going to share a copy of the slides as well as the recording, so that people are able to watch back or have a better understanding after the session. If there's no further questions, have you got any further comments you want to make, Simon and Helen, or are you ready to wrap things up?
No, again, other than to apologise again for the appalling technical issues at my end.
And mine, Simon, you weren't alone. Sadly, nearly a year on from these virtual webinars, and the technology still isn't perfect on every occasion. I think, just by way of final comment, I think I would say my experience has been during the last year that there perhaps was a slight dip in activity in the first lockdown, where people were less inclined to set up their own businesses or move to rivals, and everybody was just hanging fire and waiting for the pandemic to be over. But I've definitely noticed an increase in activity. I think people aren't waiting to jump ship anymore. They're not waiting to set up their own businesses because this pandemic and this slightly odd working from home situation is extending So I think definitely it's not a time to be sat on our laurels assuming that the danger is has been paused effectively during the lockdown, because I've started to see an increase in this sort of activity more recently. I don't know, what's your experience, Simon?
Yeah, I think people are used to lockdowns. They know how they can operate. Everyone's set up for home working. The businesses I'm speaking to, see this, I think, rapidly coming around to the view that 2021 is, we're in this for the long haul now. And whenever we get back to the office in whole or in part, there's going to be a lot more home working. So I think it's important that where you've got covenants or you're thinking about future contracts, building in protections that, as I was saying earlier, for example, enable you to police what's going on in a world where people aren't all in the office now, and to just give some thought as to how that might work in your business.
Yeah. Well, certainly virtual court hearings are here to stay. All these injunctions are done virtually now, or almost all of them, without any real issue, actually, most of the time.
Yeah, certainly what I'm seeing this is the virtual hearings are definitely here to stay. Some like them, some don't, but
depends who you're in front of.
Yeah, true. The call list is so long. I think people want to. The backlog needs to be cleared, and if it helps, and it'll help keep control costs as well, because you can, if you're working from home and preparing for, or in the office preparing for a virtual hearing, you're not having to sit around court waiting for the hearing before you to overrun. You can be getting on usefully with other work. I think that we're probably digressing into litigation small talk now rather than restrictive covenants.
Right, should we call that a day for the session? I think there's no more questions that have come in on the chat function, but please do feel free to send inquiries directly to Helen and Simon if you'd rather not share them publicly on the chat function, and they'll be happy to help you. Thanks again, Helen and Simon, and for being so calm in the face of bad Wi-Fi signal. It's really appreciated, and everyone's been through it, so yes, at least we're keeping it real. But yes, thank you everybody for joining us, and as we've mentioned, we'll share the recording and the slides with you shortly. So thanks again, and we'll share information about any upcoming sessions with you as soon as we can. Thank you everybody.